The court sentences someone to 12 months probation, and on the very same day, the head probation officer signs paperwork stating the defendant completed all conditions of probations and paid all fines and fees, and requested the case to be closed successfully the same day. Welcome back to the writer's room. This is where stories usually begin before they ever become an editorial. Sometimes I already know where I'm going, other times the paperwork takes me somewhere I never expected. And today, that's exactly what happened. This morning, I made a simple post, an old newspaper clipping from 2001, a white Ford Bronco. And if you grew up in Baldwin County, you probably knew exactly whose Bronco that was before you ever read the article. It was one of those vehicles everybody remembered. Now, let me be clear, that post wasn't about trying to embarrass Bill Massey. Matter of fact, if you actually read my caption, it said the exact opposite. We all have a past. We all have moments we probably could handle differently if we had another chance. History isn't always about judging people. Sometimes it's about remembering it so we don't repeat it. But then y'all started talking. Some people said, why bring up the past? Other people said, nobody's perfect. Some called it accountability, others called it petty. Some said, look at all the good he's done since then. And as I sat there reading the comments, I realized something. This story wasn't about Bill Massey. The story was the conversation. So I started asking myself a question. If people believe the past shouldn't matter, does it not matter for everybody else? Or does it only not matter depending on who we're talking about? And that's when the writer's room took a completely different turn because another public official came to mind, Chief Magistrate Judge Shane Geeter. Now, public records show Judge Jeter was arrested and charged with DUI and failure to maintain lane. He publicly denied driving under the influence. Because of his position, an outside prosecutor was appointed, another judge recused himself, and eventually the case was resolved with a negotiated guilty plea to reckless driving. Now, this is where I stopped reading headlines and I started reading the paperwork because the paperwork doesn't care about popularity. The paperwork tells its own story. The sentence says 12 months probation. Simple enough. That's what the court ordered. Then I turned the page and this. The head probation officer with Judicial Alternatives of Georgia signed a request to close case successfully on May 8th, 2026. Now here's what caught my attention. May 8th, 2026 is also the day the court placed Judge Jeter on probation. The court sentences someone to 12 months probation, and on the very same day, the head probation officer signs paperwork stating the defendant completed all conditions of probations and paid all fines and fees, and requested the case to be closed successfully the same day. Now, maybe there's another court order that explains all of this. Maybe there is, maybe there isn't. That's exactly why we read the paperwork. So naturally, I got a question. Was there an order terminating probation immediately? If there was, show it. Was he expected to report to JAG like everybody else? Weekly, monthly, phone report? Was he subjected to random drug testing, random alcohol testing? Was he required to complete any counseling, any DUI classes, any victim impact panel, community service? Or did another court order modify those requirements? Because if there's another document that explains this timeline, I'd love to read it. And just when I thought I had every document, I noticed something else. Every filing in this case was available on the public docket. The citation, the appearance bond, the recusal order, the order assigning a new judge, the accusation, the plea paperwork, the probation paperwork, the request to close the case, the receipt, everything. Everything except one document. The docket clearly lists a negotiated guilty plea entered on May 12th, 2026. The docket tells me it exists, but unlike almost every other document in the file, it isn't publicly viewable. So that brings into question, if he was sentenced on May 8th and probation was requested to be closed on May 8th, then how did he have a negotiated plea on May 12th? So Why is the one document that explains this negotiated plea is the one document that the public can't open from the docket? Now, before anybody jumps to conclusion, I'm not saying anything improper happened. There may be a perfect, legitimate reason. I don't know. And that's exactly why new media doesn't speculate. So here's what we did. We've already filed an open records request asking for the negotiated plea and the completed plea terms. Because I don't investigate to prove myself right. I investigate to answer questions. And if the guilty plea explains everything, outstanding. And if it raises more questions, then we'll follow those too. And while I was reviewing those records, another familiar name appeared, Detective T.J. Hargrove. And if you followed new media for any amount of time, you know that name. He's in the Julie Jackson body cam footage. He was the one initially responding officers in the Ronnie Reed's investigation. And public court record also reflects that years ago, he had his own DUI related case. And I'm not saying one case proves another. I'm simply pointing out the same names continue appearing as I continue reviewing public records. And noted, Detective T.J. Hargrove cases was null price. Interesting. So let's get back to this morning. Our people ask me, why bring up something that happened 25 years ago? Here's why. Because history isn't about humiliating people. It's about understanding patterns. It's about asking whether the same standards applies to everybody, whether you're a sheriff, whether you're a judge, whether you're a deputy or a detective. The standards shouldn't change. And that's why I love the writer's room. I woke up this morning thinking I was posting an old newspaper clipping about a white Ford Bronco, and by the end of the day, the paperwork had taken me somewhere completely different. That's how investigations works. One document leads to another, one question leads to another, and one answer creates another question. This story isn't over. We're waiting on the negotiated plea, and we're waiting on the plea terms. If there's another order explaining why 12 months probation became a request and closed probation in 12 days, we'll read that too. Because new media doesn't stop at headlines. We don't stop at opinions. We don't stop at rumors. We stop when the paperwork stops. And right now, there's still another page to read. This is Lamar King Sr., investigative analyst, new media, where the truth will never be silenced. Be great today. Peace.